So this is part two of our lecture on defamation. Now, we've been discussing imputations. Imputations are the defamatory imputations that arise out of a publication. Now, these are the defamatory meanings that arise. What defamatory meanings may arise from the ordinary meaning of the publication? Now, imputations arise from the natural and ordinary meaning of the words used, and they also arise from the innuendos. That is the double meanings, the words, but the meanings between the lines. Now, intention is irrelevant. This is very important. What matters is what you say or show, and the information plus the innuendo, not what you mean to say. So it's not a defence to a defamation action to say, well, I didn't mean to imply that they were corrupt. I didn't mean to imply that they'd had an affair. I didn't mean to imply that they'd stolen something. If the words plain and simple, or the innuendo, the imputations from the words, contain those meanings. And this can be the difficult thing, because remember, in defamation you are required to defend not just the ordinary plain meaning of the words, but also all the secondary meanings, the imputations that arise from the words. And this can be very, very challenging for us as journalists unless we're conscious of this and write very clearly. Imputations arise in two ways, by the natural and ordinary meaning, and that includes any meanings a reader may draw, double meanings, inferences, reading between the lines, decoded meanings, so on and so forth. Innuendos can arise through specialised knowledge, which is called innuendo. That is, something may be defamatory of a person if only one other person, other than the plaintiff, understood the defamatory meaning. So something may be defamatory if it carries a defamatory meaning to someone with special knowledge. If I said, for example, I was driving down Bondi Road the other day and I noticed Mr. Williams, the town clerk, coming out of number 3 Johnston Street off Bondi Road. Now, on the face of it, there's nothing defamatory about that, just an observation of a person coming out of a building. Yes, but what if some people knew that that address was a brothel? That would be a defamatory publication, because there was an implied meaning, there was a contained meaning in there that the town clerk was a person who was the sort of person who would frequent a brothel. That would be defamatory. It would cause others to think less of him. For example, here's some examples we've put down. When travelling for work, Jack and Jill booked into a double room at the hotel. Now, there might be a literal meaning. That's the literal meaning. Jack and Jill booked into a double room at the hotel. That's okay. But there might be an inference that, therefore, Jack commits adultery with Jill. There might be inferences that Jack spends less time with his wife than with his friend, Jill. In other words, the imputations from these statements: when travelling for work, Jack and Jill booked into a double room at the hotel. Jack commits adultery with Jill. Jack spends less time with his wife than with his friend Jill. The imputation is that Jack is unfaithful and promiscuous. Now, those meanings are contained within those statements, and you would have to defend them. As I say, this can be challenging, and indeed it can be quite difficult in some circumstances to prove that that's actually what happened. And imputations, as I say, become issues where it can be very, very difficult to defend things that you didn't actually necessarily mean. If, for example, I said, I'm writing a column and I say, I broke my arm recently in a sporting accident and I went to see a Dr. John Smith of Balmain who treated my arm. Well, I wouldn't be treated by John Smith again because I had a terrible infection in my arm, I had subsequent operations, and now I've lost most of the feeling in my arm. Now, on the face of it, you might think, well, hang on, I can prove all those things because they're true. Yes, but here's the rub. In that statement, there may well be inferences derived that John Smith is not a very good doctor. John Smith is a person who is not well trained in the practice of medicine. John Smith is the sort of person who should not practice medicine. John Smith is the sort of person who is not qualified to practice medicine. Now, although I can prove that my treatment was less than satisfactory insofar as it happened to me, I can't prove all these other things. I can't necessarily prove, for example, that John Smith is not qualified to practice medicine, because John Smith may well be qualified to practice medicine, has the requisite degrees and practicing certificates and experience and registrations, etc. I can't prove that John Smith is not the sort of person I can't prove that John Smith is not a competent doctor. All I can show is that in this particular instance, things went wrongly for me. So I know it's something of a thicket, something of a minefield, but implications and imputations are the key to defamation actions, and they can be extraordinarily difficult, as I say, to defend and to defend well. Let's turn to defences. Defences in the field of defamation, in all practical purposes, for journalists, we should really be relying on three main areas. Firstly, the overwhelming defence we should be relying on is truth, or what's called truth or justification. There's a second area of defence which those who are writing restaurant reviews or film reviews or opinion pieces can rely on, and that is honest opinion. There is a defence of honest opinion. And there is a third area where what we publish may be although defamatory, may be privileged for some reason. For example, if you're reporting a court proceeding, provided it is properly and fairly reported, then what's said in the courtroom, if reported by you, although it's defamatory, you can't be attacked for that defamation. But overwhelmingly, truth is the important defence, and we should insist, of course, and maintain our standards that what we publish and write and broadcast is true, and we can defend it from an accusation of defamation on the basis that it is true. So let's look at the defences. As I say, truth or justification, honest opinion, consent, privilege, innocent dissemination, and a small defence of triviality. Remember, defamation law is contained principally in the Defamation Act. There used to be state jurisdictions, and defamation was an ancient common law right and contained in the common law. It still is, but it's principally governed these days by a national uniform law called the Uniform Defamation Act. And this is an act agreed to by the states and the Commonwealth and passed by all the states and by the Commonwealth. So the law, in a statutory sense, is uniform across the country. So if I refer to sections, it'll be the sections of the New South Wales Defamation Act. But as I say, these provisions are mirrored around the country. So let's look at the defence of truth. It's not as simple as it sounds. You'd be surprised to know. Defamatory imputations must be true to attract this defence. Now, they don't have to be completely true. They don't have to be 100% true, but they must be, to use the words in the section 25, they must be substantially true. Substantially true means true in substance or not materially different from the truth. But it's important to know they don't have to be 100% true, but they must be substantially true. The burden of proof is on the defendant, that is the person who has made the publication. The standard of proof is on the balance of probability, so it's not beyond reasonable doubt. It's not a criminal standard. Here is an important thing. The evidence of truth must be admissible. I'll discuss this in a moment. Now, why should truth be a defence? Well, pretty much because if something is true, it's true. And the courts have always held, and in fact there's a nice statement of it in Robe and Smith's newspapers, a 1924 case, the presumption is that by telling the truth about a person, their reputation is not lowered beyond its proper level, but is merely brought down to it. So things that are true are, as I say, a complete defence against defamation. This was not the case, by the way. In New South Wales, there used to be a test under the old law that a thing had to be true and in the public interest. Now, this opened a whole minefield for journalists and publishers, because they not only had to prove that something was true, but that it was in the public interest to publish it. And as you can imagine, courts were reluctant to hold that there was ever a public interest in publishing anything about another person. So let's talk about this issue of truth and admissibility. Not only must the statement be true, but you must be able to prove its truth. Now, this can be difficult. Say, for example, you were given a leaked document. The person who gave you the document says, look, this is a true record of the minutes of a meeting. You read those minutes and you think, well, there's a great story here, a story about corruption or malfeasance. However, if the person sues you, you write a story about the people involved, they sue you for defamation, you say, well, look, the story's true because I have the minutes of the meeting where these things were said. But they say, well, yes, those minutes are obviously incorrect. They're obviously a fault. They're obviously a falsehood. You say, no, they're not, because I know them to be true. My source, who I absolutely trust, has given me this information. However, if the source is not prepared to come to court and support you, in other words, to give evidence on your behalf, then you're in big trouble because you can't prove it's true. So not only does the matter have to be true, but it has to be able to be proved to be true in court with admissible evidence. Now, if your source, for example, doesn't want to be identified and said, look, I'm not coming to court, I'm not giving evidence for you because, after all, that will identify me, that will mean I'll be in trouble at work, I'll lose my job, and I don't want to do that. I don't want to jeopardize my own position. You're in trouble and you really can't prove that it's true. So just be careful of that. It must be not only true, but you must be able to prove that it's true. Honest opinion is governed by Section 31. Honest opinion relates to a statement of opinion that expresses a subjective opinion. Now, subjective opinions are less easy to categorise as true or untrue and generally relate to issues on which we as a society agree to disagree. For example, issues of taste. Italian food is better than French food. Moral issues. The death penalty is always wrong. Now, these are issues of opinion, and the law does allow people to express opinions, provided they meet the legal test of the defence of honest opinion. Now, honest opinion is the area of law which restaurant reviewers, film reviewers, reviewers of all kinds, and writers of opinion pieces and so on would rely on. But there are some important considerations if you're relying on the honest opinion defence. For a start, it must be an opinion, that is, it must be an expression of opinion of the defendant and not a statement of fact. So I think that so-and-so is something rather than so-and-so is. So it must be an expression of opinion. Bill Smith is a terrible actor is a statement of fact. Whereas I considered Bill's performance in such and such a production to be bad acting is a statement of opinion. So make sure it's always grounded as opinion and not as fact. Secondly, you can't rely on an honest opinion defence unless the opinion is related to a matter of public interest. Now, this means that it must be related to some general matter about which people might be interested to hear. It must be based on material that is called proper material. Now, this is important. Your opinion must be based on material that is substantially true or published on some occasion of absolute or qualified privilege. So, to return to my film review example again, if I said Nicole Kidman is a disgraceful actor who can't act her way out of a paper bag, that's defamatory and not really a statement of opinion. I'm stating as a statement of fact. If I said, though, that I've just viewed Nicole Kidman's last 10 movies, in all of them I find her portrayals very wooden, I consider her to be a person with very poor acting skills, that's a statement of opinion because, firstly, it's an opinion, secondly, it's on a matter of public interest, and thirdly, it is based on proper material, that is material that is substantially true, i.e. I did see the films do exist, and she does perform these roles in those films. Now, the defence of honest opinion is defeated if the opinion was not honestly held. So if it's malicious, for example, if I indulge in payback or malicious behaviour and I don't really hold these opinions at all, then the defence will be defeated. Here are some examples of the honest opinion defence. John only walks his dog once a day. Now, that's a statement of fact, isn't it? John only walks his dog once a day. That's a statement of fact. It's okay if you prove it's true. What about John treats his dog appallingly in that he only walks it once a day. Now, that's a statement of opinion. John treats his dog appallingly, followed by a statement of fact. He only walks it once a day. So if I can prove the statement of fact is true, he only walks it once a day, my opinion can find an honest opinion defence because it's based on a fact. But what about if I write this? John treats his dog appallingly. Now that's a statement of fact. It's okay only if you can prove that the treatment is objectively appalling. Now that may be very difficult. You may be able to prove an instance of appalling treatment, but not a general one. So just be mindful of that an opinion must be based on some material that is true or substantially true. Let's turn to the defence of privilege. Privilege protects a speaker or a publisher from defamation action, even if the material is untrue. It's absolute or qualified. Generally, privilege attracts in a range of areas. There are some complicated and quite complex issues of qualified privilege, but as I say, these are probably best left to lawyers. Let's look at an issue of absolute privilege covered by Section 27, and this is important. This means that proceedings, for example, in Parliament and in courts and tribunals and in many other bodies, and you can look at the annexures on the Defamation Act, which list all the bodies which have privilege. And that means that proceedings and documents and evidence and debate within those bodies are privileged. That means that provided you report it fairly, you can't be accused of defamation if you report material there fairly. So in other words, we can report anything that's said in Parliament, so-called Coward's Castle. Anything said in Parliament is privileged. Documents ordered to be published in Parliament, publications and debates and proceedings, that's Hansard, evidence to committees and so on. In courts and tribunals, the same. If evidence is filed with a court, judgments and orders and determinations, etc., are privileged. The same for royal commissions. Evidence and documents given to royal commissions are privileged, but be careful. Unless the evidence or the documents are filed with the Royal Commission and are given in evidence to the Royal Commission, they don't attract that privilege. As I say, you can find out whether the body is one of those bodies to which privilege attracts by looking at the Defamation Act. There's a whole range of them, from courts to racing tribunals to appeals bodies to royal commissions and so on and so forth. Qualified privilege is an interesting area. There are just two distinct areas at present. Firstly, statutory qualified privilege. That's one is where this is Section 30, where there is a reciprocal legal, social or moral duty to publish and receive particular information. Say, for example, if you're giving someone a reference or a teacher is giving someone a school report. And then there's political qualified privilege, which is the implied right of free political communication, the so-called Longy defence. And this is a relatively new development in the law, and which has arisen in High Court decisions over the last 20 years. Statutory qualified privilege, Section 30, a defence of privilege is available if the recipient of the information has an interest or apparent interest in receiving the information and the conduct is reasonable in the circumstances. Now, this question of whether the conduct is reasonable in the circumstances is a tricky one because there must be a public interest in the matter. There must be taken into account the extent it relates to public functions, the seriousness of the imputations, the extent it separates facts and allegations, the nature of the business environment of the defendant, public interest in expeditious publication, sources, integrity of sources, and so on and so on, and so on and so forth. So in other words, whether conduct is reasonable in the circumstances is taken into account by considering all of these factors. There is an area of defence which relates to a fair and accurate report. This is contained within Section 2829 of the Act. This defence is available where defamatory material is contained in a fair and accurate report of proceedings of public concern or a fair copy, extract or summary of public documents. And this covers reports of Parliament, parliamentary documents, open court proceedings, court documents, proceedings of various official bodies, and so on and so forth. There is another defence related to what's called innocent dissemination. This is Section 32. Essentially, the defence is available for those circumstances where, you didn't really know what was contained in the publication and you disseminated it for some other reason. For example, a newsagent might be thought to have participated in the defamation by publishing, that is, selling publication which contained defamatory imputations. But they would be able to rely on innocent dissemination defence in the sense that they were publishing the matter as a subordinate distributor and that they didn't know the publication contained defamatory material and it was not reasonable that they should have known. And the lack of knowledge didn't result from the defendant's negligence. I would imagine that an ISP, for example, an internet service provider, would be able to rely on the same defence for defamatory material that was published over the net. It protects those who don't have the capacity to exercise editorial control over the content. Although to some extent, I suppose, this is one of the arguments that's being fought out in the digital space at the moment. To what degree should ISPs or other mediators of information on the web have some responsibility for what is published? There is a defence of triviality, where the circumstances of the publication are such that the person defamed was unlikely to suffer harm. And as I say, this is a very, very uncommon and small area of the law. If you apologise, does it make things better? Well, never apologise for a defamation unless you have got legal advice to do so. It's very, very tricky to do it, and you should be very careful about what you're doing. And really, it's not a game for anybody other than an experienced lawyer. There is an offer of amends apology procedure set out in the Act, which does offer a complete defence. But in general, an apology does not remove the right of a person to sue. It may affect the amount of damages they ultimately get, but it does not necessarily provide you with protection against being sued. And all you may find is that you've both apologised to the person and then find that they sue you for money anyway. So don't apologise unless you get legal advice that it's important to do so. There is an offer of amends procedure under the Act, which can provide a complete defence to a defamation action if an offer of amends was reasonable and not accepted. In other words, if you said within a certain time limit and within the constraints imposed by the Act that you offered to apologise, offered to make it good, offered to correct, and that offer was refused, this may be a complete defence to a defamation action. It has to include an offer to publish a reasonable correction of the material, an offer to pay legal expenses, and it must be done within a certain time frame. As I say, sections 12 to 20 contain the procedure, but this is not something to be undertaken, as I say, without the express intervention of a lawyer or the media lawyer you're dealing with. If you receive a lawyer's letter in defamation, don't be frightened. Often letters are sent simply to scare you off. Just consider carefully, was my publication defamatory? Do I have a defence? If I have a defence, I should feel confident to proceed. As I say, don't be scared into early apologies without seeking advice from your in-house media lawyer or a media lawyer that is contracted to provide you with advice. And remember that defamation equation. It's very important. Publication plus an imputation plus identification equals defamation, right? With a defence, it's a safe publication. Without a defence, it is an extremely high-risk publication. But if you defame someone with a defence, it's a perfectly safe publication and you should feel able to proceed. So ask yourself those key questions again. Is what I'm about to say defamatory? If it is, do I have a good defence? And good luck with your writing. Thank you.